Hi, my name is Erwin Kratz. I'm an attorney at Fenimore Craig in the Employee Benefits Group. I'm going to talk to you today about the recent Supreme Court decision in the Affordable Care Act case and the effect that that decision has on employer plans going forward. As we all know by now, the Supreme Court largely upheld the statute with some minor exceptions that don't apply to employer plans. And so you need to comply with the Act's requirements that are coming into effect in the short term, in the next year or so, as well as those that are going to be coming into effect in 2014. Many employers may have been hiding their head in the sand, assuming or hoping that the court would overturn the legislation. That's no longer a viable strategy, even if you think that Congress might change hands in the fall and a new president and a new Congress might repeal the legislation. That's unlikely to happen in its entirety. It's unlikely to happen in any significant way that affects you, and you need to be ready to comply with the statute and get busy to do that. So what are the requirements that you need to be paying attention to in the next year or so? There's a few things that you may not be expecting or may not have heard of that you need to be ready to deal with if it occurs. And one of those is that many insured plans are going to receive a refund from their insurance policy, from their insurance company, under the medical loss ratio rules. If you receive one of those refunds, don't just keep it for the employer or refund it to the employees without looking at the issue and determining whether those are plan assets that need to be handled one way or the other. It's going to be different for each employer, and it's not something to just do a knee-jerk response to. You need to look at the document and determine under the plan asset rules what to do with that refund. Another requirement that you need to make sure on a document basis you're complying with, as well as practically, is the $2,500 limit on flexible spending account reimbursements as of plan years beginning after September 23rd, 2012. Another issue that many employers may not have realized that they have to comply with is the payment of a $1 per beneficiary fee under their group health plan, whether it's insured or self-insured. You're going to need to pay that fee to the government as of October 1st, 2012 on an annual basis. Another big requirement, document-wise, is to generate the summary of benefits and coverage, which is like a 4-page summary of the summary plan description that all employer plans are going to need to distribute to their participants at open enrollment time as of plan years beginning after October 1st, 2012. If you're an insured plan, your insurance company will generate that document and provide it to your employees. If you're a self-insured plan, it's your responsibility to generate that document and provide it to your employees. And you may be able to get some help in that regard from your claims administrator, but it's your responsibility. You cannot just rely on a third party to comply with that requirement. Another big issue is W-2 reporting as of 2013, as of January 31st, 2013. All employers will need to include on the W-2s they issue to their employees the cost or the value of the medical coverage provided to their employees in the prior year. There are some exceptions to that for small employers, but that's something to address with your W-2 provider to make sure that you're in compliance with that. And the last notice requirement that's coming down the pike in the short term is the requirement to provide notice to your employees in 2013, in the spring of 2013, of the availability of the state insurance exchanges which are being set up and are at various stages of being set up. Looking a little bit further out, your plans will need to be amended as of 2014 to provide some changes in the coverage under the plans. For example, pre-existing condition exclusions are going away entirely in 2014, and some other requirements that will be fairly mechanical to comply with, and you'll get help from your insurance provider or your third-party claims administrator to comply with those requirements. But another big thing that's coming in 2014 is the so-called Payorplay mandate. That's going to require employers to provide minimum essential coverage to their employees and to pay a certain percentage of that coverage or face a penalty of up to $2,000 or $3,000 per full-time employee, depending on a number of factors. That's something you should look at with your accountant to determine how that tax will apply to you, if it will apply at all, and to get a strategy for how to amend your plan to either avoid the tax or perhaps to change your benefits coverage entirely and pay the tax. Depending on the circumstances of each employer, one or other alternative might make more sense. And so that's something to really get into the details with and to figure out a strategy for compliance with during 2013. Don't wait till 2014, it'll be too late to do it then. The bottom line is the Act's in effect. There's a lot of requirements that employers need to be paying attention to and complying with, and burying your head in the sand is no longer a viable option.